Okay, so without any further ado, then I'd like to introduce you to today's excellent speaker, Professor Emmett Macfarlane. So Emmett is a full professor of political science at the University of Waterloo, whose current research spans a wide range of topics, and that includes constitutional amendment, unwritten constitutionalism, free expression and hate speech, and also legislative responses to court decisions on charter rights. And Emmett is also the author slash editor of really a pretty staggering 7 books. He's also the author of many, many journal articles. And he has a really fantastic Substack called Declarations of Invalidity, which I strongly encourage everyone to check out when you can, preferably right after this session concludes. So Emmett, thanks so much for being here, and it's my really distinct pleasure to hand over the virtual mic to you.
Thank you very much, Richard. Hello, everyone, and I want to start off by thanking Richard and the Center for Constitutional Studies for this invitation to speak today, and to all of you for taking the time to listen. My talk is based on a recent paper published in Osgoode Hall Law Journal, and that paper was inspired by Quebec's Bill 96, a law that purports to unilaterally add new provisions to the Constitution Act of 1867. And these 2 provisions state, first, that Quebecers form a nation, and that French shall be the only language of Quebec. It is also the common language of the Quebec nation. Quebec suggests that it is possible to make these additions to the text of the Constitution of Canada by virtue of Section 45 of the amending formula of the Constitution Act of 1982, which allows provinces to make amendments to the Constitution of the province. Defenders of Bill 96 partly rested their argument in favor of the amending provisions on the basis that the provisions were being housed in a section of the 1867 Act titled Provincial Constitutions, effectively treating that section as equivalent to the Constitution of a province for the purposes of amendment. And I'll explain today why that does not follow, but I want to first note that Quebec has already departed from this argument when it subsequently passed another law purporting to make another unilateral amendment to the 1867 Act, this time in relation to a provision that does not fall under the Provincial Constitution section. Bill 4 purports to immunize the Quebec National Assembly and its members from a constitutional requirement in Section 128 of the 1867 Act, requiring parliamentarians of the federal parliament and all provincial legislative assemblies to take a prescribed oath to the monarch. For reasons I'll explore today, both bills are plainly unconstitutional attempts by the provincial legislature to amend the national constitution. But my claim today will not rest simply on the fact that the matters implicated by the bills fall under different procedures of the amending formula. In fact, that's too easy an argument. With respect to Bill 96, for example, the text of the amending formula makes it clear that any amendment pertaining to the use of English or French within a province requires recourse to, at the very least, the bilateral amending procedure under Section 43, subsection B, and requires resolutions not only of the relevant provincial assembly, but of the federal House and Senate as well. Similarly, the provision about Quebecers forming a nation is a statement implicating Canada's multinational character, and in fact, a contestable one at that. Who counts as Quebecers, and how does the Quebec nation relate to the various First Nations and Inuit people in that province? As an attempt to have such recognition conferred by the national constitution, it is plainly something that falls under the purview of the general amending procedure, requiring the consent of both the House and Senate, and at least 7 provinces representing at least 50% of the population. And I'm happy to address further questions about which procedures can affect what changes under the amending formula, but my paper and my talk today will focus on making a much more fundamental argument about provincial unilateral amendment of the Constitution of Canada. That is, provinces simply have no authority to make direct unilateral amendments to the Constitution of Canada, full stop. And this argument flows quite clearly from the text of the amending formula itself, from relevant jurisprudence, and from historical and contemporary constitutional practice. And I will address each in turn while elaborating on the distinction between provincial constitutions and the Constitution of Canada. Now, provincial constitutions are notoriously difficult to define. They have evaded widespread public or scholarly attention, in part because, as with the Constitution of Canada generally, they are not confined to a single document. Unlike the Constitution of Canada, their constituent elements are often not labeled constitutional at all. Only British Columbia has a document referred to as a constitution. Within the ambit of provincial constitutions, though, we know there are the internal machinery of government and key institutions of a province, including the executive, legislature, and the electoral system. And importantly, some elements of these are reflected in specific provisions of the Constitution of Canada, but are also comprised by ordinary provincial statutes, including quasi-constitutional statutes like the Quebec Charter of Human Rights and Freedoms and other provincial human rights codes. The unwritten components of the provincial constitution include core conventions like responsible government and many related conventions pertaining to the relationship between the practical and formal executive, the operation of cabinet, the relationship between cabinet and the legislature. There's just little doubt that within these contexts, provinces have considerable authority to implement amendments. They can alter the operation of their legislature, enact electoral reform, reform their bureaucracies, establish new rights-protecting instruments and institutions. Changes within this general scope are limited by the Constitution of Canada, implying a fundamental distinction between provincial constitutions and the Constitution of Canada, the national constitution. For example, a change to the core convention of responsible government may not be possible for a province to unilaterally enact if it were determined that such a change would affect the office of the lieutenant governor, whose position is entrenched in the national constitution and referred to in the amending formula. Similarly, electoral reform at the provincial level that ran counter to the democratic rights of the Canadian Charter would be impermissible as well. Canada's amending formula itself is complex. It contains 5 different distinct procedures, including the general procedure of Section 38, requiring resolutions of the House, the Senate, and at least 7 provinces representing at least 50% of the population. Section 41 is the unanimity procedure, specifying a set of matters requiring the approval of the House, Senate, and all 10 provincial assemblies. Section 43, the bilateral procedure, is used for matters affecting one or more, but not all provinces, including alterations to provincial borders and amendments to any provision that relates to the use of the English or the French language within a province. Section 44 permits Parliament to make changes to the Constitution affecting the Executive, House of Commons, and Senate. And Section 45 permits provinces to make changes affecting the constitution of the province. The text of each of these amending procedures refers explicitly to amendments to the Constitution of Canada, except for Section 45, which does not refer to the Constitution of Canada, but instead to the Constitution of the province. This distinction has important consequences reflected in existing constitutional practice. Neither Section 45 nor its predecessor, Section 92(1) of the 1867 Act, has ever been used to directly alter existing provisions or add new ones to the text of the various acts comprising the national constitution. This includes the provincial legislative enactment abolishing Quebec's upper house in 1968. That act did not purport to amend or repeal the relevant sections of the BNA Act. Instead, it made changes to the Provincial Legislature Act and a host of other provincial statutes. The result was not a direct repeal of the relevant constitutional provisions, but to render those referring to the Legislative Council effectively spent or impliedly repealed. It is noteworthy that Quebec's own 2021 consolidation of the 1867 and 1982 Acts takes a similar position, explicitly stating that Section 71, establishing Quebec's Legislative Council as part of the legislature, and the remaining sections were not directly amended by the 1968 legislation. This distinction is important. It reflects the fact that the references to elements to the provincial constitutions in the national constitution ought not to be equated with the provincial constitutions themselves, which exist for the purposes of amendment as wholly subject to ordinary provincial legislation. So how then was it possible for Quebec to have abolished the Legislative Council in this manner in 1968? Central to this understanding of how Section 45 operates is the wording of its predecessor instrument, Section 92, subsection 1 of the Constitution Act 1867, then the BNA Act, and which Section 45 effectively replaced in general scope and application. Section 92(1) provided for the amendment from time to time, notwithstanding anything in this act, of the Constitution of the province, except as regards the office of the Lieutenant Governor. This wording, particularly notwithstanding anything in this act, would be unnecessary if the amending power being granted to provinces was such that they could directly amend the national constitutional text. The wording also reflects the placement of Section 92(1) within Section 92, the section of the division of powers relating to the exclusive powers of provincial legislatures. Recall that the BNA Act contained no express general procedure for the amendment of its provisions. Amendments to it required resort to the Parliament of the United Kingdom. So as Warren Newman writes, Section 92(1) allowed amendments to the Constitution of the province that, in their effect, amount to alterations to provisions of the BNA Act, but none of them, quote, purported expressly to amend them in terms. Rather, the words of those sections remain unchanged and unrepealed, end quote. This is in contrast to Section 91(1), which was a later provision added in 1949 to allow the federal parliament to make amendments to the Constitution of Canada without needing to make such requests to the UK Parliament. The phrase Constitution of Canada, appearing nowhere else in the 1867 Act at that time, would come to be defined narrowly by the Supreme Court as not permitting amendments to the whole of the BNA Act, but only those matters of interest to the federal government. Moreover, as Newman notes, the Supreme Court confirmed that Section 45 has essentially the same scope as its predecessor in the 2014 Senate reform reference. This is reflected in the distinct wording of Section 45, which, unlike the other amending procedures, does not refer to amendments to the Constitution of Canada, whose definition was changed in 1982 with the entrenchment of Section 52. The notion that the Constitution of Canada comprises the provincial constitutions is as inaccurate as it is ahistorical. As Campbell Sherman wrote, the 1867 Act says very little about most of the significant matters of government structures and operation at the provincial level. These fall within the ambit of provincial constitutions. He argues that provincial constitutions may be defined negatively as being those constitutional matters not dealt with authoritatively in the BNA Act. The national constitution simply provides structure in which parts of the provincial constitutions are located and expressly entrenches certain features, most prominently the lieutenant governor. Thus, according to some scholars, Section 45, by virtue of operating by ordinary legislation, and despite its presence in the amending formula, is properly understood as simply conferring jurisdiction over provincial matters, and not, as might otherwise be suggested, delegating the power to amend the supreme law of Canada, properly understood. Now, a potential complicating factor remains in the form of Section 52, subsection 2 of the Constitution Act of 1982, which defines the Constitution of Canada as including the acts and orders referred to in the schedule of Section 53. Among those acts are ones pertaining to elements of provincial constitutions, including the Manitoba Act of 1870, an order admitting British Columbia into the Union in 1871, the Alberta Act and Saskatchewan Acts of 1905, both statutes of the federal parliament. Now, it's important to note that many of the provisions in these acts specifically contemplate becoming spent or subject to implied repeal. They are establishing provisions, and they are not written in such a manner as to be subject to direct amendment by provincial legislatures, but as enabling legislatures to enact ordinary legislation to effect changes to their internal provincial constitutions. So, for example, the Alberta Act of 1905 contains many clauses that establish key features of the executive or legislature, including appointments to cabinet, the location of the capital, the composition of the legislature, all of which are set out with the expectation of future change via language such as, until the said legislature otherwise provides, ... After 1982, given the Section 1552 definition of Constitution of Canada, it becomes important to recognize a fundamental distinction between whether an amendment is entrenched, at least in the sense that it requires more than an ordinary legislative enactment to change, which legislative enactments made under Section 44 or 45 cannot be, and supreme law as part of the Constitution of Canada, which amendments under Section 44 are, and Section 45 are not. On top of this distinction, there are also specific instances of overlap between the Constitution of Canada and those provisions of the constitutional acts referring to the Constitution of the province due to their entrenchment. The remaining provisions that establish or refer to limited parts of the provinces, themselves part of the Constitution of Canada, are thus subject only to indirect amendment or implied repeal by virtue of Section 45. So the formulation I'm advancing here is straightforward and has the benefit of according with both text and history. Provinces never had authority to directly amend the various national constitutional acts. The BNA Act, as an imperial statute, could only be directly amended by the Parliament of UK, at least until the inclusion of Section 91(1) in 1949. By convention, such amendments would come by a way of a joint resolution by the Federal House and the Senate. The provinces could not make such requests, and in fact, when they tried, they were rebuffed. Instead, Section 92(1) gave provincial legislatures a legislative power to amend the internal constitution of a province. Section 92(1) essentially operated to empower provinces over matters relevant to their provincial constitution, just as the rest of Section 92 empowered them to legislate in regards to matters under provincial jurisdiction as set out in the division of powers. Therefore, provinces could legislate in relation to certain provisions of the BNA Act, but could not directly alter them. Just as jurisdiction over a head of power does not extend the authority to amend that head of power, the power to amend the constitution of province does not extend to the authority to amend relevant establishing provisions in the Constitution of Canada, let alone add new ones. And this is why Quebec and other provinces were free to abolish the upper chamber of their legislatures, rendering any constitutional provisions referring to them effectively spent or repealed by implication. Indeed, in 1894, the Nova Scotia Assembly, frustrated by failed attempts to abolish its legislative council by simple act, passed an address to the Queen to request that the UK pass legislation affecting the abolition. The British government replied, quote, that an amending act would be inexpedient since the provincial legislature already had the power to alter the constitution of the province. This rejection was thus based on the distinction between the power to directly amend provisions of the 1867 Act and the power of provinces, which they already held, to amend the matters referred to by those provisions as legislative amendments to the constitution of the province. Recall again that this legislative power provided for amendments to provincial constitutions notwithstanding anything in the BNA Act itself, rather than empowering them to make amendments to those elements of the BNA Act. This is also reflected in constitutional practice since 1982. Before Bill 96, no province had ever directly amended the text of the Constitution of Canada. Yet where it was impossible to assert such authority under Section 92(1), it is now, as Bill 96 demonstrates, something provinces are willing to attempt to assert under Section 45. It's not merely the text or history behind the relevant provisions at stake that speak against this, but 4 decades of established practice under the 1982 amending formula as well. The vast majority of amendments to the internal machinery of the provinces are enacted via legislation making no specific references to Section 45 or constitutional amendment at all. These include statutory changes setting out, for example, the rules of the legislature. Occasionally, provinces have enacted legislation that specifies that they are indeed amending the provincial constitution or employing Section 45, although examples are quite rare. Direct amendments to the Constitution of Canada, including the various acts and orders referred to in Section 52, have always required recourse to one of the other amending procedures. There have been 13 amendments to the Constitution of Canada under the 1982 formula. Parliament has, under Section 44, modified the formula for apportioning seats in the House 3 times and granted Nunavut representation in the Senate. The general amending procedure under Section 38 has been used but once in 1983 to make modest but substantive amendments concerning Aboriginal and treaty rights. The remaining 8 amendments were made under Section 43's bilateral procedure. Each of these amendments affected only one province, and some are more relevant to our discussion than others. 6 of the amendments had direct and obvious relevance for Confederation-style bargains of the Constitution of Canada. So, for example, providing for the fixed link bridge to PEI. But 2 Section 43 amendments involve matters that only implicate individual provinces, but because they called for direct textual amendments to the Constitution of Canada, they could not be enacted unilaterally under Section 45. In 1993, Section 16.1 was added to the Charter of Rights, recognizing the dual official language communities in New Brunswick. Note that nothing prevented New Brunswick from enacting an ordinary statute guaranteeing such rights under its provincial constitution using Section 45. They used Section 43, however, because they wanted to entrench the rights in the text of the Charter. Moreover, this is not because this particular provision implicated Section 43B, which refers to amendments relating to the use of the English and French language. Instead, the equality of status between linguistic communities and the specific educational and cultural rights reflected in that provision do not fall explicitly within the ambit of Section 43B. Instead, in order to enact these rights in the Constitution of Canada, in order to reflect them in the text of the National Constitution, Section 43 was required. And this example goes also to the core issue that on its own implicates the validity of Bill 96 in Quebec. Provincial constitutions and amendments to them are subject to the Charter. By contrast, textual provisions of the Constitution of Canada are not, on the principle that one part of the Constitution of Canada cannot invalidate another part. In 2001, Section 43 was used to change the name of Newfoundland to Newfoundland and Labrador in the text of the Newfoundland Act. There can be little question that the name of a province is anything but a matter belonging to the authority of the Constitution of that province. Indeed, the name Newfoundland and Labrador was widely in use within provincial documents before the amendment was enacted. And while the Newfoundland Act exists to give effect to the terms of union agreed to between Canada and Newfoundland, changing Newfoundland's name has no effect on the substantive obligations implicating Canada. Yet because the Newfoundland Act is among the acts listed as part of the Constitution of Canada, amendments to its text required recourse to Section 43. And this relates to the purpose of that amendment. In the words of Lawrence O'Brien, the MP from Labrador at the time, the amendment was to confer recognition of Labrador in the name by the Constitution of Canada, and indeed by the country as a whole. Quote, "We, as a parliament, recognize Quebec's distinct character in 1995 through a resolution, and we recognize New Brunswick's bilingual character in 1993 through a constitutional amendment. And so today we are recognizing the dual geography and dual nature of Canada's newest province." Unquote. This is precisely the sort of recognition Quebec seeks with respect to the Bill 96 provisions. It is not recognition within its own provincial constitution. They want recognition in the national constitution. Historical and contemporary practice make it clear that provinces are not free to unilaterally amend the text of the Constitution of Canada, that this is meaningfully distinct from the sort of indirect amendments affected to do things like abolish the upper houses of provincial legislatures. There's not one instance of a province having enacted a direct amendment to the Constitution of Canada, and the use of Section 43 until this point affirms that it is required for such textual changes, even when they concern matters that are fundamentally internal to the constitution of a province. This is not because provinces always lack the amending authority to enact similar measures in provincial legislation. Yet to have such a change explicitly reflected as supreme law in the Constitution of Canada is distinct from a change to a provincial constitution, as our constitutional practice has always reflected. Now, turning to the jurisprudence. The courts have struggled with, and at times have openly avoided, defining the precise parameters of provincial constitutions and their relationship to the Constitution of Canada. Generally speaking, the Constitution of a province is not regarded as part of the Constitution of Canada. In the pre-1982 case, Quebec v. Blakey, the court determined that provisions of Quebec's Charter of the French language were ultra vires the authority of the province because they violated Section 133 of the BNA Act, which guarantees the use of English or French in the Quebec legislature. The court recognized that Section 92(1) may encompass matters beyond the provincial constitution's section of the BNA Act, particularly those that bore on the operation of an organ of the government of the province. Yet this did not, in the court's view, make Section 133 unilaterally amendable. The court states, "Indeed, the argument goes too far because, as pressed, it would permit amendment of the catalog of legislative powers in the succeeding catalog of classes of subjects in Section 92. The court endorsed the view of the trial judge that Section 133 is not part of the Constitution of the province within Section 92(1), but is rather part of the Constitution of Canada and of Quebec in an indivisible sense. The court in Blakey thus speaks to a direct conflict between a provincial law and a provision of the Constitution of Canada." In the related case, Manitoba v. Forest, the court found Manitoba language legislation inoperative to the extent that it violated Section 23 of the Manitoba Act 1870, which protects the use of English and French in the legislature. And it's worth noting that the Manitoba Act is a statute of the federal parliament. Its validity was retrospectively recognized by the passage by the UK Parliament of the Constitution Act of 1871. This added context prompted the court to expand on the relationship of the Manitoba Act to the Constitution of the province. Court writes, quote, "Although in a certain way, the whole Manitoba Act may be said to be the Constitution of the province, it is apparent that the amending power conferred by Section 92(1) cannot have been intended to apply to the whole of this statute any more than all the provisions of the BNA Act touching upon the Constitution of the province in this wide sense can be subject to it." So although this clarified to some extent the limitations of Section 92(1) as an amending power, and the scope of the Constitution of the province, the court does not fully elaborate on the relationship between the Constitution of Canada and the provincial constitution. And the post-1982 cases that analyze provincial constitutions provide some clarity in some areas, but less in others. In Ontario v. OPSU, which involved Ontario legislation prohibiting public servants from carrying out certain political activities, Justice Betts writes for the majority and draws on Blakey to elaborate on the scope of Section 92(1), which was the relevant provision when these restrictions were first enacted. According to Betts, legislation implicating, quote, provisions relating to the Constitution of the federal state considered as a whole or essential to the implementation of the federal principle are beyond the reach of the amending power bestowed upon the province, end quote. Similarly, these provisions of the 1867 Act that constituted a fundamental term or condition of the Union formed in 1867 are also beyond the reach of the Constitution of the province. So Betts kind of refines Blakey, where Blakey endorsed the view that Section 92(1) extended to matters beyond the scope of provincial constitutions, section of the 1867 Act. OPSU specifies areas where federal elements of the Constitution of Canada also work to put matters beyond the reach of provincial amendment. In the 1993 case, New Brunswick Broadcasting, the court determined that the privileges of a provincial legislative assembly were part of the Constitution of Canada, but the judges explicitly avoided determining whether the Constitution of Nova Scotia was entrenched in the Constitution of Canada via Section 52. Chief Justice Lemaire at the time raised a caution against the idea that Nova Scotia's provincial constitution was entrenched via Section 88 of the 1867 Act. Section 88 establishes that the constitution of the legislature of each of the provinces of Nova Scotia and New Brunswick shall, subject to the provisions of this act, continue as it exists at the Union until altered under the authority of this act. Lemaire notes that the continuance of a provincial constitution, as contemplated by Section 88, is something quite different from giving it status as part of the Constitution of Canada. So he cited two lower court decisions that held that certain provincial constitutions were not part of the Constitution of Canada for the purposes of Section 52(2). Justice McLaughlin, as she then was, wrote, quote, I would also be concerned about a reading of the word continue in Section 88 of the Constitution Act 1867 as be entrenched, since this section concerns only the provincial constitutions of Nova Scotia and New Brunswick. Such a reading would raise questions regarding the other provincial constitutions, end quote. So the relationship between provincial constitutions and whether they are part of the Constitution of Canada, or at least entrenched within, remains an entirely unsettled question from the perspective of the Supreme Court, but one in which judges have cautioned against in lieu of a fundamental distinction between the two. What these disparate comments have in common is the notion that whatever is in the Constitution of Canada is beyond the legislative powers of provinces to amend unilaterally. Much like Blakey's conclusion that Section 133 was indivisibly part of both the Constitution of Canada and the Constitution of Quebec. So how does one reconcile these statements with the power of Quebec to abolish its upper house? The key is the distinction between direct amendment of the Constitution of Canada and the authority of provinces to amend matters relating to their provincial constitutions, as I've already noted. Section 88 refers to the continued existence of the constitutions of New Brunswick and Nova Scotia. Those constitutions are not, at this point, recognized by the court as an entrenched part of the Constitution of Canada, but the textual reference of Section 88, which therefore neither comprises those provincial constitutions, nor is itself subject to direct unilateral amendment. So Section 88 is part of the Constitution of Canada. The provincial constitutions themselves are not in that context. In order to ensure the equality of status between provinces, The other provisions of the Provincial Constitutions section of the 1867 Act, as well as the various establishing acts in the Section 53 schedule, should also be regarded as just that, establishing provisions that refer to parts of provincial constitutions and whose matters, if not overlapping in a way that implicates federal authority or a bargain of confederation, can only be subject to indirect amendment by way of legislation. The result is that provinces can make amendments to their internal machinery of government within the confines of the sort of constitutional limits noted in OPSU and as reflected in the amending formula. And those changes can even render establishing provisions in the Constitution of Canada effectively spent or impliedly repealed, but they cannot directly amend the constitutional text because the provisions themselves are part of the Constitution of Canada. The jurisprudence overall is not particularly clarifying, and some of the preceding comments by judges were made in obiter. Nonetheless, they generally support, at least implicitly, the formulation I have articulated thus far. My position assumes that all provisions within the relevant Constitution Acts are part of the supreme law of the Constitution of Canada, as consistent with the definition in Section 52. Unless one adopts the perspective that certain provisions within those acts are not part of the supreme law, and hence not part of the Constitution of Canada, it is difficult to reconcile the text of the various amending procedures, the history of constitutional practice around amendment, with the idea that provinces can make amendments that expressly alter the text of the national constitution. One conception of the relationship here needs to be consistent with both the supremacy clause of the 1982 Act and to the text and structure of the amending formula itself. The coherent view, the one consistent with text and practice, is to recognize that Section 45 allows for amendments to the Constitution of the provinces, but only that can indirectly amend the matters within those establishing provisions, so long as those matters are not subject to another amending procedure. We also have to have a regard for the very purpose and act of constitutional amendment. The intent of the Quebec government, indeed the intent of the legislation, is to confer recognition of the Quebec nation and French as its official language by the Constitution of Canada. This is reflected in statements by Quebec's Minister of Justice to the effect that the provision would have constitutional, that is legal and jurisprudential significance, to the extent that the provision could be used to inform the interpretation of the Charter of Rights, or that it might influence the balancing act courts sometimes undertake under Section 1, the Charter's reasonable limits clause. The provision itself is beyond the scope of Section 45. The Charter was designed as a nationalizing instrument, and implications for its interpretation are implications for the entire country. More fundamentally, the nation provision has obvious implications for Canadian federalism and for Canada's national identity. The so-called mega constitutional rounds in Meech Lake and Charlottetown were significant, complex, highly contested attempts to reach new agreements about the overall status of the Constitution. Constitutional recognition of Quebec's special status in the form of a distinct society provision or a nation provision was central to these negotiations. And yes, the nation provision in Bill 96 obviously differs in wording from the distinct society style provisions in the two failed accords, but it is the same form of special recognition akin to those clauses and should be regarded as having important implications for the vision it promotes of Canadian federalism, even if, and despite the preceding argument, it is only treated as having merely symbolic effect. The central difference between an ordinary legislative enactment and one that purports to make an addition to the 1867 Act is that the latter is properly regarded as an attempt to confer recognition of the special status of Quebec on behalf of the rest of the country. That is not something that can be done under Section 45. Nor can the nation provision be dismissed as simply constituting a statement of sociological or societal fact. The idea that all Quebecers form a nation is deeply contested, especially given the presence of Indigenous peoples in Quebec and the various nations from Cree to Inuit to Mohawk, among others, to which they belong. The proposed amendments in Bill 96 also arguably implicate the constitutional architecture. Recognizing Quebec as a nation in the national constitutional text goes to the heart of the federal principle. Even if it's framed as merely symbolic, it has implications for the federal identity of the country and for conceptions of Canada as a multinational federation. The reality of Quebec's distinctiveness cannot be denied, but the particular characterization of Quebec as a nation and the wording used matters. It has implications for how the federal principle is understood and how the country as a whole is conceived. The proposed provision also has implications for another unwritten constitutional principle, the rights of minorities. The nation provision is a statement on the total category of Quebecers, granting constitutional recognition of nationhood to a subunit of the Federation, itself inhabited by a number of different Indigenous nations, carries with it normative weight. The constitutional architecture as currently constructed reflects Canada's multinational character. Section 35 recognizes Aboriginal and treaty rights. The treaty relationships, now commonly referred to as nation-to-nation relationships, form a fundamental part of our constitutional structure. The nation motion, as currently formulated in Bill 96, purports to inhabit the members of those Indigenous nations within Quebec as belonging to a larger national entity to which they may or may not belong. My claim here is not that the amending provisions of Bill 96 are unconstitutional by virtue of unwritten principles or the architecture concept, but that these inform a proper assessment of which amending procedures can validly be used. The use of Section 45 renders these provisions of Bill 96 unconstitutional. It is troubling then that the Prime Minister, indeed each of the federal party leaders, is apparently unwilling to defend adherence to the constitutional amending formula, instead publicly suggesting that Quebec could proceed with these amendments. As the comprehensive set of instructions for who gets to write the rules of the Constitution, there's arguably no more fundamentally rule of law question for a constitutional democracy than this one. The political incentives here are obvious. With a federal election ever looming, and with Quebec seats representing nearly a quarter of the House of Commons, the desire to avoid alienating Quebec is overriding. Yet it is not justifiable. Elected representatives have a responsibility to uphold the Constitution, even in the context of politically sensitive matters. Nor is the Prime Minister's justification for Quebec's unilateral action, premised in part on the fact that the federal government has already recognized Quebec as a nation, satisfactory. The parliamentary motion approved in 2006 that this House recognized that the Quebecois form a nation within a united Canada is worded differently than the proposed provision in Bill 96 and may differ in content depending on how one understands who comprises the Quebecois. But more importantly, a parliamentary motion has no constitutional import. It's not a statement of law, let alone constitutional law, and does not obviate the need for a constitutional amendment to adhere to the formula's requirements. If federal elected representatives are supportive of Quebec's proposed amendments as a matter of substance, then they should pursue a legitimate amendment by way of the bilateral or multilateral procedures, depending on which are deemed necessary. Instead, it appears the constitutional validity of Quebec's proposed amendment will ultimately rest with the courts. Until such time, the Bill 96 provisions should be viewed as having dubious constitutional legitimacy. It is of some concern that the apparent federal apathy toward Bill 96 has arguably emboldened provincial governments to pursue further unilateral amendments to the Constitution of Canada. In addition to Quebec's Bill 4, we have the Saskatchewan First Act, which also purports to add provisions to the 1867 Act to assert that province's jurisdiction. If these attempts at unilateral amendment of the Constitution of Canada are permitted to stand, we open the door to an increasingly incoherent written constitution filled with unilaterally enacted provisions that seek to alter judicial interpretation of its various pillars, from the Charter of Rights to the division of powers, and no doubt eventually running into each other in increasingly incoherent, if not outright contradictory ways. I'm aware of no other federation in the world that allows its constituent subunits to unilaterally amend the national constitution. Instead of a body of supreme law, we would be left with a litany of unilateral and asymmetrical caveats a cacophony of symbolic grievances, a series of trite entries added to or altered at the whim of the various subunits of Confederation. Such a development is contrary to the text and purpose of the amending formula, history and contemporary practice of amendment, the very idea of a national constitution comprising supreme law. It is, in fact, nothing short of a new pattern of constitutional sabotage, and these so-called laws should be challenged and struck down as the patently unconstitutional acts as they are. And I will leave it at that. Thank you.